thrilled to be invited to this conference, especially as a lawyer. I understand that I am neither fish nor fowl here. And I'm going to address questions that lawyers don't ask, and neither do theologians. So I hope I don't make a dog's breakfast of both of those fields in this presentation. But let's talk about the decision-making church as a legal corporation. Most of you will know of the early American Baptist John Leland, the Virginia minister instrumental in securing an American Bill of Rights. There are monuments to Leland's famous interview with Madison near Orange, Virginia, and the SBC ERLC's building in Washington, D.C. is known as the Leland House. However, fewer Baptists know that Elder Leland eventually moved to Cheshire, Massachusetts, and won a seat in the state legislature. In 1811, legislator John Leland rose to speak vehemently against a new bill in the Massachusetts legislature. The bill at issue, said Leland, was a grave threat to religious liberty. Leland delivered 30,000 signatures from Massachusetts voters urging a rejection of the law. It was, he said, a dagger of state tyranny. It was based on the thinking that had caused the Crusades. It had cost millions of lives. This section puts the knife into their hands, said Leland. A knife, sir, which is more pestiferous than Pandora's box. What had angered Leland so much? It was a bill to make churches into legal corporations. Leland's anger shows that Baptists of the past understood the relationship of the law and the church, and especially the extent to which the law may recognize the church, is a deeply theological and ecclesiological issue worthy of careful study and action. Incorporation does not bother many Baptists today in the 21st century. No SBC has passed a resolution against it. Congregations do not debate it. Preachers do not preach about it. Theologians breeze past it. Yet we should think about the legal local church because it still matters. From America's founding through World War II, the legal systems of the United States gave ever wider berth to private religious organizations. And because of this relaxed approach, churches did not have to be particularly careful in church legal matters. Or as Dr. Arnell indicated, maybe even in our church confessions. The law allowed churches to resolve disputes in whatever way the leadership of those congregations deemed best. Today's American culture and law, however, are not so kindly disposed toward charity, religion, or ecclesial authority. Charitable immunity started unraveling in the 1940s. In the late 1970s, the Supreme Court said deference to religious authority wasn't a matter of constitutional compulsion, and repeated shocking revelations about the institutional response to sexual misconduct has undermined the belief that churches are best at policing themselves. These changes increase the legal public significance of ecclesiology and polity. To explain why, this paper first takes a high-level view of the legal history of the local church. The gathering of believers as a local church has always been and will continue to be have public legal effects. So we'll see at key moments in the early church, among early English Baptists and among early American Baptists, how the law has shaped the expression of the church and vice versa. In the second section, we'll briefly discuss how Baptists, given today's legal climate, can organize themselves to perform their divinely ordained mission, cognizant of cultural and legal forces that might pull them off track. Our first stop is the legal situation of the early church and Paul's litigation strategy to protect it. Greek and early Roman society allowed private associations to flourish. The Athenians had several words to describe associations, including the ecclesia, the democratic assembly that governed that city. The Romans called private associations collegia. Sometimes a collegium was recognized by the state as a separate legal body. These incorporated Roman collegia could buy and sell and hold property. For example, Rome's state church was controlled by the privileged Collegium Pontificum, headed by Pontificus Maximus, usually the emperor himself. There were also collegia devoted to religion, the trades, and burial societies. But these collegia were typically private associations. Under Roman law, they were given the privilege of self-organizing. According to the Digest, they are legally authorized to make whatever contracts they may desire with one another, provided they do nothing in violation of the public law. By the time of Jesus, however, the Romans were generally opposed to new groups. This opposition was difficult to enforce across the empire, so it tended to be reactionary. In 64 BC, the Senate dissolved all collegia that conflicted with the public interest, But then Julius Caesar, Augustus, Tiberius, Claudius, Trajan, each had to decree new restrictions in light of new threats. The opposition was so fierce, Trajan at some point pointedly refused to allow even a company of firemen in the city of Nicaea, writing to his governor, "Whatever title we give them and whatever our object in giving it, men who band together for a common end will all the same become a political association before long." So the empire was inclined to stamp out associations that were not venerable, authorized by the state, and willing to perform public services. However, Julius Caesar had made a remarkable early exception to this policy: Judaism. Caesar's favor was due to political assistance from Antipas, the father of Herod the Great. Antipas had rescued Caesar at Alexandria with an army, and as a reward, Antipas was installed as the governor of Judea, and Judaism was recognized as one of the few lawful non-Roman religious groups in the empire. Caesar wrote to Roman cities asking them to let the Jews assemble in accordance with their native customs. "If you've made any statutes against our friends and allies the Jews," he wrote to leaders, "you will do well to revoke them because of their worthy deeds on our behalf and their goodwill toward us." So Caesar's approval allowed Judaism to be seen as a venerable tradition rather than as a threat to public good order. With this background, it's easier to see the pitched legal battle at the beginning of the church. Rome was opposed to new associations, but as a fulfillment of Judaism, the early church was part of a venerable tradition, a new school of an old collegium. This gave the church a legal space to organize itself and spread. Of course, many Jewish religious leaders, for political and religious reasons, were opposed to these followers of the Way, as early Christians identified themselves. And in town after town, Paul's preaching led to disturbances: Antioch and Pisidia, Iconium, Lystra, Philippi, Thessalonica, Ephesus, and finally in Acts 21, Jerusalem. And so after a riot in the temple, Jerusalem officials were again in a position to define the Way as an innovative cult and therefore a threat to Rome's militarized peace. In Acts 22, the Sanhedrin turns Paul over to Rome, where he's prepared to be flogged, in a scene reminiscent of Jesus' handling right before the crucifixion. What happened next could be seen as the first litigation strategy to preserve legal space for the local church. When he learned of a plot against his life, Paul invoked the protection of Claudius Lysias, the Roman commander. Claudius Lysias sent him to the local governor, and Paul began his defense to Felix by explaining his beliefs in terms of Judaism. "But I admit this to you, I worship the God of my ancestors according to the Way, which they call a sect, believing everything that is in accordance with the law and that's written in the prophets." Felix held over judgment for his successor, Festus. Paul gave a similar testimony to him: "Neither against the Jewish law, nor against the temple, nor against Caesar have I sinned in any way." When Festus asked the opinion of the then reigning Herod Agrippa, Paul gave yet another apologetic. Paul testified that he was saying nothing other than what the prophets and Moses had said. Note that Paul's appeals were not necessarily defensive or even legally necessary. Agrippa and Festus both agreed that Paul could go free if he could just stop appealing to higher levels of authority. Acts closes with Paul in Rome, preparing to testify, assured by an angel that he must testify directly to Caesar. Paul's legal apologetic, then, allowed the early church to develop in a Roman Empire that was suspicious of new groups. The followers of the Way worked in the same legal space as Judaism and Roman collegia, and Rome tolerated the Way for a time, despite pleas from Jerusalem's religious leaders. Empire-wide persecution of Christians did arrive, of course, under Nero at about the same time of the Great Revolt in Jerusalem near 70, which, of course, ended the Caesar's benevolent view of Judaism. But Paul's successful legal battles allowed the infant church to grow up under a temporarily tolerant national government. From Paul, we jump forward to the era of early Baptists in England, where another national government wrestled with religious tolerance. The legal system faced by early Baptists in England was in some ways more restrictive than Rome's had been toward early Christians. The Church of England's political goals could be aptly summarized by the key laws of Henry VIII and Charles II, the acts of supremacy and conformity. Like Caesar, the English crown claimed the right to regulate gatherings and associations. The king's consent was, quote, absolutely necessary to form any lawful group. The king had the power to create artificial people, or corporations, which included both cities and towns, as well as the joint stock investment companies like the Hudson Bay Company or the East India Company you might be familiar with. The state church had this legal protection. For example, a chapel might be deeded to the name of the local minister. But if the minister died, the chapel didn't go to his legal heirs. It went to the next minister. The minister was a kind of corporation under English law. But nonconformists could not obtain recognition from the crown. Instead, England went to incredible lengths to deny them any comfort or protection under English law. About 1592, under Elizabeth I, John Penry testified that it is against our will that we go into the woods or secret places, as we are not ashamed of the gospel of Christ, but we know that meeting in woods, in caves, and mountains is a part of the cross. Elizabeth's successor, James I, was no better. When separatist exiles petitioned James for tolerance, they were ignored or worse. In 1612, Baptist Thomas Helwys published a small book on the mystery of iniquity and made a startling claim for religious freedom. Men's religion to God is between God and themselves. The king shall not answer for it, neither may the king be judge between God and man. Let them be heretic, Turks, Jews, or whatsoever. It pertains not to the earthly power to punish them in the least. Helwys sent a copy of his book to King James I. He was promptly arrested and died in Newgate Prison in 1616. James did inadvertently create legal space for separatist churches. James gave royal charters to two sets of investors to start colonies in North America. The crown wanted natural resources and gave those companies wide latitude in governance. And perhaps unsurprisingly, conformity was not a very big concern amongst investors back then. And as a result, in about 1619, a group of dissenters in Leiden decided to embark on a group to settle in the Plymouth Company's land. Thus, a legal innovation allowed the Pilgrims to live in religious freedom as subjects of the English king, even as that same king was harrying dissenters at home. By 1642, a civil war broke out, and in the middle of it, we see a notable public apologetic for Baptist principles. The First London Confession, 1644, opens with a public purpose of distinguishing Baptists from Anabaptists. This is a confession of faith of 7 congregations or churches of Christ in London, which are commonly but unjustly called Anabaptists, published for the vindication of the truth and information of the ignorant, likewise for taking off those aspersions which are frequently both in pulpit and print unjustly cast upon them. The 1644 London Confession also includes a lengthy article about the relationship of Baptists to the civil order, pledging obedience mostly. Although we should suffer ever so much from the king in not actively submitting to some ecclesiastical laws which might be conceived by them, yet we are bound to yield our persons to their pleasures. Parliament's military forces eventually won the Civil War, giving rise to a temporary commonwealth, but after Cromwell's death, monarchy returned in the form of Charles II, and yet again the political power of high church Anglicanism led to the persecution of nonconformists. A royalist parliament passed in short order the Corporation Act, which prevented nonconformists from holding positions in government of cities or other corporations. The Act of Uniformity, which required the use of the Book of Common Prayer and services and led to the ejection of more than 2,000 ministers from the Church of England. The Conventicle Act of 1663, expanded in 1670, which prohibited any religious gathering of more than 5 unrelated people. The 5 Mile Act in 1665 prevented ejected ministers from being within 5 miles of any incorporated city or town. And in 1673, the Test Act imposed a religious test on all government offices. Charles' successor was his brother, James II, a Roman Catholic. James' reign put Baptists of the time in a very difficult position. James had publicly supported religious toleration, and one of his goals was to repeal those royalist laws, the Clarendon Code. A number of Baptists supported the king and were appointed to offices of the crown. But James repeatedly tried to govern without Parliament and had a strong autocratic vision of government. Does it strike any match up with anything you might have experienced in your life? In 1688, James issued an indulgence to Catholics and nonconformists, and his wife had a Catholic son, which triggered fears of a permanent Catholic monarchy and a request by some nobles to William of Orange asking him to come to England with his wife, Mary. William, of course, was a member of the Dutch Reformed Church, so he was a nonconformist. And so in a surprising twist, William of Orange, King James II, and Parliament all saw toleration of at least some nonconformists as a key to their political power in retaining office. So as you know, William and Mary ascended to the throne in the Glorious Revolution, and in 1688, Parliament promptly passed a Bill of Rights, and an act for exempting their Majesties' Protestant subjects dissenting from the Church of England from the penalties of certain laws, otherwise known as the Act of Toleration. The Act of Toleration allowed dissenters to be ministers, allowed nonconformists to meet, and indirectly allowed them to hold property. But you'll notice the minister and the place of worship and the congregation all remained legally distinct, as in the Anglican concept, not as in the typical independent or Baptist concept. Ownership of the so the act allowed nonconformist ministers to register with their county, but they couldn't hold meetings until they'd also registered a public meeting place. So a traveling evangelist was entirely outside the concept of the law. Ownership of the meeting place required other workarounds. Even after the Act of Toleration, Parliament was not going to recognize dissenting churches as legal corporations, and therefore congregations could not hold the property in the name of the congregation. A wealthy landowner could allow the meeting on his or her property, but landowners leave congregations, and landowners die, and one can never quite be sure that the improvements made by the congregation to the land would actually remain for their benefit. The workaround used most often was the ancient English idea of a trust. Dating back to the 12th century Crusades, a trust recognized that property could be legally owned by someone for the benefit of someone else. So when Crusaders left, they would sign their property over to a confidant to be managed in their absence. But when the warriors came back to England, this promise was not always kept. The Crusaders could appeal to the king's chancellor for a ruling in equity or fairness, and these chancery courts consistently required the owner to use the property for the benefit of the intended persons, so long as the trust was not for an unlawful purpose. But you can see during the darkest years of supremacy and conformity, a trust for the benefit of non-conforming religious services would be for an illegal purpose, and therefore not enforced by the courts. Nonconformists then, after the Act of Toleration, could have the purpose of their trusts enforced. It became possible for congregants to give or bequeath land to one or more trustees to be, as in a typical example, quietly used and enjoyed for the worship of Almighty God by Protestants dissenting from the Church of England and known as Baptists. Equity would enforce this kind of gift mostly. But if the trustees diverged from their congregation, it was difficult to call these legal owners to account. So the system allowed by the Act of Toleration was not perfect, but it was practical enough to meet the needs of countless churches. And more importantly for American Baptists, the Act of Toleration became the default situation in most of the American colonies. Finally, then, we come down to the law of the Church and Law of North America. Again, you're already likely familiar with the role of the First Amendment in that story and maybe even the disestablishment of state churches, but you may not be as familiar with the importance of general incorporation laws. This turns out to be a uniquely Baptist story, again, because John Leland played a small part in at least all of these arguments. And in the interest of time, we'll consider Leland's involvement in general corporation laws, that last step. In 1792, Leland moved to Cheshire, Massachusetts, a Baptist settlement in the Berkshires. In 1811, Leland reluctantly stood for election to the Massachusetts legislature. Leland's candidacy was precipitated by an 1810 decision by the Massachusetts Supreme Judicial Court, Barnes versus inhabitants of First Parish in Falmouth. At the time, Massachusetts required individuals to pay taxes for the support of some church in their parish, any church. You just had to pick one. Conscientious objectors could, in theory, direct their funds to their own church or congregation. Barnes, in the case, wanted to support an unincorporated society of Universalists in his town, but Massachusetts courts said that only incorporated societies could receive funds. In the next session of the legislature, a bill was introduced to automatically incorporate all religious associations so that these societies would then have the power, legal power, to tax their members. This propelled Leland into the legislature. Leland's apoplectic speech on the floor of the Massachusetts House was widely published. He starts by noting that Massachusetts Constitution required that no sect of Protestantism could be made subordinate to the others. But, Leland said, here we find some, quote, so well convinced of the all-sufficiency of Protestant Christianity and the completeness of its code to govern in all things that they will not, they cannot, in good conscience, submit to a power which they believe, in their best judgment, was never given to the government to exercise. These are peaceable subjects of the state, ready to arm in defense of their country, freely contribute to support of Protestant Christianity, but they cannot pay a legal tax for religious services. This, sir, is one of the essentials which constitutes them as a distinct sect. Have they not been reduced to subordination? How many lawsuits, how much cost, how much property has been taken from them to support other societies? Leland went on to say that the objection of Baptists was not to the difficulty of becoming a corporation, but to the effect that incorporation would have as envisioned by the legislature. The petitioners, Leland said, don't ask to be known as in law as corporate bodies, but to be so hidden from the religious corporate bodies shall not know them, and thereby fleece them. But to give Baptists against their will a corporate power to make tax collections of their members was anathema. As a result of Leland's efforts, the bill was largely gutted, and so in 1812 the legislature passed a law allowing gifts to unincorporated associations. But Leland had joined others in criticizing a remaining obstacle to the law, recognizing the church's own organization. In order to hold and use property as a body, churches had to obtain a corporate charter, and at that time the only way to obtain a corporate charter was from the legislature. Because it took a legal action of the state to issue a church would have to find a friendly legislator to introduce a bill, grovel for a vote by the state legislature, have it passed in both houses, and hope that it was signed by the governor, and all that without amendment. You could make it through that process and find your bill had been amended and kind of gutted the purpose of your religious association. The time and expense of this procedure would be prohibitive, even if the church making the request was already, not by definition, a religious minority. A similar problem was faced by for-profit corporations. They, too, would have to go through this process in order to get a corporate charter, and they found themselves subject to the whims of the state legislature and the corruption involved in that. In many states, lobbying firms had sprung up which would secure the necessary votes for a fee. This gauntlet therefore made it impossible to treat the various groups equally at the very minimum. Some states had banned altogether any corporation for religious purposes. Other states tried to limit religious corporations to the purpose of property ownership alone, especially with fears about corporations back in the 1850s. There were really strong fears, at least in my home state, about Catholic corporations or Catholic monasteries. So in Missouri's Constitution, for example, at that time, you'll see provisions that say, okay, we'll recognize religious corporations, but they can't own more than an acre in town and 5 out. So there's very much concern about corporations eating up the land or being somehow subordinate to foreign powers. All of those anti-Catholic concerns are raised by this new doctrine of the corporation. People are fearful and try to limit it, especially if they seem to claim religious purposes. But the better solution came to be general corporation laws, in which incorporation became a mere administrative act, usually by the Secretary of State, therefore, instead of a special act of the legislature. So in most of your states, if you'll go back and look at the name of the corporate code, it's called the General Corporation Law of Missouri or the General Corporation Law of Texas. That doesn't mean it's corporations generally. It's to distinguish it from a corporation which received its charter as a special act of the legislature. So here, finally, we see a system that is typical today. Today's general corporation laws give recognition to the legal organization, the legal choices made by the organization itself with minimal interference. The state gives all organizations similar powers and does not treat any religious organization differently unless the question involves a decision about religious doctrine or leadership under the First Amendment. So what do these vignettes tell us about the decision-making church as a legal corporation? Well, here are a few ideas, and certainly in question time, if there's any, we can talk about some others. First, let me suggest the local church must be ready to give an honest apologetic to local, state, and national government. Whenever people gather, government notices, and even in the United States, it continues to notice. As much as it is necessary and useful to send the right people to Washington and the right groups to Washington or the state capitol even, it's not sufficient. Giving the apologetic requires vigilance at all levels, but especially it requires a local church that knows where it is and why it is. The church involves gathering together, so we must be ready to give an account in the same way the Apostle Paul and Elder Leland did in their times. In that sense, the organization of a local church is always a political act and must be accounted for as such. Second, good stewards can and should use legal tools consistent with the church's spiritual mission. This takes some careful balancing and rebalancing. In the words of the Baptist Faith and Message, the church should not resort to the civil power to carry on its work. But I believe it is appropriate for the state to honor the private arrangements of gathered churches with respect to their property and leadership. Anything less than that interferes with the, quote, right of free and unhindered access to God on the part of all men and the right to form and propagate opinions in the sphere of religion, both of those in Article 17 of the Baptist Faith and Message. In our time, good stewards will probably use the legal rules of incorporation rather than the legal rules of unincorporated associations. First, because the New Testament seems to describe the church as a body, something different from the individuals themselves, in the same way the corporate law recognizes that. So Dr. Yarnell talked about last night, we talked about last night, that offering between the congregations was not an offering between individuals. It was an offering sent from one body to another. And likewise, when Ananias and Sapphira are accused of holding back money, the implication was they were supposed to be giving that money to the church. The church is bigger than you. It's different from you. It existed before you and will exist after you. It has perpetuity. It doesn't die when you die, even though your membership in the church ceases. So the church has always thought of itself and organized itself as something separate from its members. And to the extent that concept is recognized in the law, that's what we call a corporation. It's a legal body separate from its members. Corporations are also useful for prudential stewardship reasons. The unincorporated church cannot own its own property, which can create confusion. And additionally, the law traditionally recognizes no difference between the assets of the unincorporated association and the assets of its members. What's that mean? That means if someone in the association causes a legal harm to others, the court will look to the assets of all the association's members if you're not incorporated. So few of us would think to risk our house or our retirement savings or our car on the fact that our youth minister will never make a mistake that hurts somebody else. If there's a lawsuit, you didn't think I was going to put my car on the line and think about what that would do to your church if that were the rule. If you did have to put your car on the line for the mistakes of the pastor or youth minister or elders. So long as the rule does not distort the church's operation, and so long as the power from the government isn't a special dispensation to one kind of faith, incorporation can be consistent with what most Baptists believe about appropriate relationship between church and state. But, as a caution, that is not to say this set of circumstances will always continue to exist. General corporation laws are a set of general rules to encourage investment, cooperation, and involvement. This is a very particular view of the corporation as a group, and it has a sense that the group is retaining the individual political freedoms they have together. So that was the underlying idea in Citizens United versus the Federal Election Commission, which held that the First Amendment protects speech by people gathered together as corporations, just like it would protect them if they were gathered together as an unincorporated association of individuals. That same idea then led to Hobby Lobby, which said that the religion clauses of the Constitution protect the religious exercise of some corporations, at least small, closely held family businesses. Again, because the corporation, under the legal concept here, is merely a gathering of individuals. They don't lose their legal and political rights by gathering together under that legal body. But you will recall that idea generated some controversy when those decisions came down, both in matters of election law and religion. And in fact, it was shortly after Hobby Lobby, granted it was a meaningless show vote, but immediately after Hobby Lobby, Democrats in the Senate and the House tried to pass bills that would have taken that privilege out for religious organizations. Said, no, corporations are dead. They have no souls. They have no religion. We're going to go out and make sure that the Religious Freedom Restoration Act doesn't protect them. And that bill did not pass in the Senate by 3 votes. So the legislators today were so easily convinced that that ruling was wrong, that corporations are not merely the gathering of individuals, but they represent a special creature of the state, subject to the state's rules. That has enough currency, at least among one party, to produce a fairly quick reaction that the law should not reflect the concepts that were key to Citizens United and Hobby Lobby. So, however, there remains at least a number of legal scholars and politicians and others who would say the corporation is merely a creature of the state, that by agreeing to form a corporation, its members subject the corporation entirely to the state, and that these creatures of the state must reflect the government's positions on equality and religious neutrality. If this view gained currency among legislatures and courts, Baptists would again be in a position to question whether their current legal apologetic between the church and the law must change. Third, it is crucial then for the local church members and its pastor to have a deep ecclesiology and to have the legal advice that understands that ecclesiology, and then to have the integrity in their legal documents as an apologetic to the state and to each other about the operation of the church. A congregation not anchored to a vision for the New Testament church will drift with legal and cultural currents or be trapped by them. For example, churches can be trapped by a kind of faux legal conservatism, holding on to structures while the law has changed around them. So, for example, it's not too uncommon in my practice to have churches bring me an incorporated set of bylaws with a handful of trustees. If you ask those Baptist churches, what are these trustees supposed to do? The most common answer is they are there to manage and hold title to the real estate property and to sign legal documents at the direction of the church. That was the function of trustees in 1688, when the Crown wouldn't recognize nonconforming churches or allow them to own their own land or property. But if you are an incorporated church today in the United States, your state's law likely says the trustees are not passive holders of land for the benefit of others. In most cases, a lawyer will tell the church that corporate trustees, different from mere trustees, corporate trustees are the board of directors, the group the law says is ultimately legally responsible for the operation of the church. Legally, it's usually the board of directors that is responsible for the hiring, firing, and supervising of staff. Legally, it's usually the board of directors that is responsible for financial integrity. If you blow past the nonprofit guidelines, the board of directors receives special tax penalties personally for having approved unlawful financial transactions. It is usually the board of directors that is ultimately responsible for making sure reports of sexual abuse are submitted to correct authorities or responding to misconduct by employees. And in most cases, at least if you're using the default rules under most states' general nonprofit laws, it is the board of directors that will have the legal authority to override the deacons, the congregation, the pastors, and the elders. If you had asked any of those churches, what are the trustees? None of them would have identified the trustee as a biblical office or really even a very important office. But in fact, due to ignorance or neglect, their legal structure does not match their ecclesiology. That continues to have effects. There was a church recently in, I believe it was Kentucky, not a Southern Baptist church, but a different Baptist, independent Baptist church, and the congregation split. And the church was, the property was held in the name of trustees. And so the court was asked, well, what are you going to do with this group? Should we pick group A or should we pick group B? And the court very wisely, almost Solomonically divided the baby and said, actually, the trustees are there to hold that property for the use of both split congregations. So you all figured out a schedule, and the trustees will adopt it. But the trustees are there to hold that property for the benefit of whoever wants to meet as a Baptist in that town. And so whoever wants to come in, you work out a schedule amongst yourselves. Don't disrupt the peace. But that's the legal structure that was recognized by the courts because the trustees were ultimately responsible for the property of that church. A second way to be trapped by corporate law is uncritical acceptance of the new, which also creates theological and legal problems. When Americans think of corporations, they tend to think of large, modern businesses with outside investors. It can be tempting to try to identify and allocate power within the church on the basis of what seems to work in today's well-run companies. But while modern businesses are productive and even admirable in some ways, they are not structured to produce spiritually mature disciples of Jesus Christ. As a matter of conviction, the organizational chart of the church does not look like the organizational chart of General Motors or Apple. Pastors are not CEOs. Baptist elders nor deacons really operate quite like a board of directors. Instead, Baptists share a faith and conviction that each congregation operates under the lordship of Christ through democratic processes. But grabbing the nearest set of nonprofit bylaws from the lawyer you've paid the least amount of money in town can result at least, in a deeply deformed polity. And so if we really believe the church is as a result of democratic processes, if we really believe that the congregational polity is important, it should be reflected in what we tell Caesar and each other about how we operate. Another manifestation of corporatism, we'll pull aside on that. It is all too easy. I've seen elements of that both in perhaps the last generation of church theory, which we had celebrity CEOs, and so many pastors wanted to be like Lee Iacocca, or maybe even Steve Jobs, the entrepreneurial CEO. But then that kind of crested in 2008 amongst corporate scholars. Looked like CEOs were getting away with too much. And so we had a financial crisis, and at that time, lawyers and theorists stepped in and said, no, what we really need is a strong board. And I'm not saying that has driven changes, but I'm certainly saying I think that makes it easier amongst popular conception to, as we've observed earlier, replace a deacon board with an elder board. Not too different from the way we think of corporate boards, outside directors having reign over the powerful CEO. Not that those two things are interrelated. Not that there's not a good reason for biblical plurality of elders, but that it makes it a lot easier to accept that in American churches than it would, for example, for me to say, and you also need more business meetings at your church. Elders and business meetings, strong deacons and elders. One of those gets accepted easily. One of those is a hard sell, in my experience. And part of that, I believe, is the influence of large, successful organizations. Another manifestation of corporatism is what I call the Gnostic bylaws, governing documents that describe the church as a legal body separate and inferior to its true spiritual essence. The members of the church are told they are only part of the spiritual body and uninterested parties when it comes to the physical manifestation of the church. So there is a prominent non-Baptist evangelical church, orthodox in theology except for its non-Baptisticness, that its governing documents go to great lengths to define church members as, quote, a spiritual body united for spiritual purposes, but then it denies that those people it calls members really are corporate members, because corporate members are really just the elders. To be kind, this structure is probably based on a mistaken understanding of mid-19th century cases with language of that sort. And of all the possible temporal disfigurements of the ideal church, this is probably not the worst, if it's the closest thing available. But in an era when the law allows, as it does today in most cases, the church to form corporations that reflect their actual ecclesiology, to say what we mean and what we do and to have the law honor that, this division between the flesh and the spirit represents an unnecessarily confusing message about the churches and its relationship to the congregation. And in extreme cases, it allows the leaders to become untethered from their own congregations. Finally, Baptists need to plan for the day that some or all of their ministries are put to the choice between faithfulness and effectiveness. In a small but telling recent example, some Baptist churches in Prince George's County, Maryland, recently agreed to preach environmentally focused sermons to educate their congregations instead of paying a county-imposed water tax. The tax amounted to perhaps $1,000 per year, but if Caesar demands unjust amounts of money from the church that it can't pay, it's no answer to bargain away the pulpit. Without a clear gospel ecclesiology, churches naturally drift towards mere charities of the kind favored by government. The church will face more difficult questions than a $1,000 water tax. In 2017, California's religious colleges narrowly avoided a law that would have blocked students from spending state-aided scholarships at those schools. In other states, laws have made it impossible for Christian adoption and foster care ministries to qualify as state-approved providers. In fact, I think Dr. Moeller's briefing this morning mentioned a case in, I believe, Georgia that said they've been given 30 days. You're a Christian ministry, you assist foster parents to make to influence Christian foster parents, and they say because the law now in that state, you have 30 days to decide whether you're going to be Christian or foster, but you can't be both. In 2018, the Massachusetts legislature is considering a bill that would bar corporations from asserting religious exemptions or defenses to state anti-discrimination laws, including those regarding sexual orientation and gender identity. In the week before this symposium, an Ohio trial court ordered a biologically female child to be taken out of the custody of her parents because the child had expressed a desire to undergo hormone therapy to present as male. So while I believe it is relatively unlikely in our lifetimes you will have a state that directly interferes with a religious worship service, there is a significant chance that some types of Christian ministry will be prevented from engaging in the work they think the Lord has called them to do. And so we need to prepare our trustees and our congregations for those hard decisions. In cases where ministry cannot continue, churches must prepare directors and churches to consider preserving assets for religious ministry. If a Christian college cannot continue to be faithful to its vision for Christian education, what should be done? It may be appropriate to shrink operations to those that could be supported without government aid. It may also be appropriate for a convention or churches to set that ministry free to a new secular mission. But in the normal course, I believe there should be at least some effort and consideration to apportion or repay assets given from churches and conventions and Baptists that were given in expectation of gospel ministry. If gospel ministry is no longer possible, there should be some effort to redirect those funds that were entrusted, again, the very old legal concept, to make sure that some portion of those at least continue toward faithful gospel ministry. This requires, needless to say, careful legal planning and structuring of ministry, even at the local church level. So if there's anything I want you to take away from this message, I know that was a fire hose of legal and theological concepts, it's this. It is crucial for local church members and pastors to have a deep Baptist ecclesiology, to have legal advice that understands that ecclesiology, and to have the integrity in its legal documents as an apologetic to the state and to each other about the operation of the church. If you were held to the governing documents that you gave to the state and the other members of your congregation, would they really reflect the Church of Jesus Christ, or would they reflect the Rotary Club? The legal culture that our parents and grandparents had has in some ways lulled us to sleep because the law gave unusual deference to the church, or even fed the desire and ability of some to paper over ecclesiological differences or other disagreements among evangelicals. But it has become and will be increasingly important because we will be held to how we describe ourselves to Caesar. If we do not wake up, if we stewards are not able to explain ourselves and our Lord even to local or state government, we will find our congregations trapped or led astray. And with that, I have any questions? Yes.
You mentioned various aspects of bylaws. Do you have a template or sample bylaws that you would recommend churches use as a starting point?
I would not usually, I don't have a set that I recommend outside of Missouri. I'll say that much. Missouri has a very old corporation statute called the Benevolent Corporation. And the trade-off it makes, because it's so old, it allows churches to describe their polity correctly. It doesn't require a board of directors. It requires you to describe what you really do, and the law will recognize that. That's a little bit different from what is the Trinity or nonprofit law. In most states, you'll have a general nonprofit or corporation law, and usually it says, unless you go through some hoops, you're going to have a board of directors. And because I believe neither deacons nor elders nor pastors quite fit that model. That takes some elbow grease. That takes some conscious decisions to say, here's how you're going to be a little deformed by legal process. Now, if you're governed by elders, fine. Sometimes that fits. But if you really believe in strong elders and strong deacons and a congregation, it takes some pretty careful balancing based on your state's law. So in Missouri, I feel pretty comfortable about the advice I give to those churches as to how to describe their polity and also have that recognized. In other states, if you just have a nonprofit corporation law, or maybe there's a different old law in your state that allows you to say what you really do and have that recognized, I'd talk to a lawyer there about making sure your documents look like that. Yes.
And two, I went to one of those conferences as well. It was Mike Johnson. I don't know if y'all have heard of him. He's a lawyer and he wrote some things for the state.
Heard that name.
Yes, sir. He's got a ministry, Freedom Guard. So you might want to check that out.
Well, and Louisiana, of course, has got civil government, and it's its own. It too is a little bit of platypus and legal issues. So yes, if you're in Louisiana, you definitely need to talk to a Louisiana lawyer about the structures that are allowed.
If there's any explanation I've had to make of a chapter in this book, it's why on earth do you have a lawyer writing about law stuff in a book about polity? Thank you that no one in this room will ask that question.
Yes.
I'd like to ask what he just said. So you mentioned that our ecclesiology should entail a doctrine of corporate personhood, and that should have implications. If I'm following, that should have implications on how we're approaching this subject. Do you see anything else within our ecclesiology that might be infringing upon that? Or, I mean, for example, you gave the example of the Independent Baptist Church. Do you see anything that's correlated, or I don't even know how to say that?
Yeah, no, I mean, I do, like I said, I think if we really believe in both strong deacons and strong elders, which I think we do, or at least some of us do if you get us pinned in a corner, it's hard to fit that into the General Motors structure. General Motors is what you get if you pull off the shelf. You go to the internet and get corporate bylaws, nonprofit bylaws, it's General Motors. Some shareholders, they might have some rights, but really it's run by a powerful CEO and a board of directors that rubber stamps them. That's not a Baptist church. And so we sit very uncomfortably inside that model. And so if your state only allows that, you need to know that so that you realize our polity is being a little deformed by the way we hold our property together. So that it's up to churches then to know how they're being deformed. How does this box feel a little uncomfortable to me? And that's probably the key, is that we don't believe necessarily. I could have everyone draw a picture of the organizational chart of the church. It'd be interesting to see where the deacons are on that chart. But they're not quite a board of directors, and neither are the elders. And then the elders kind of disclaim some of the responsibilities of the deacons. So there's not, in Baptist concept, one group of people ultimately responsible, besides the congregation. But that's not usually what the law means by the ultimately responsible group. It has a vision of one group of people that the state can say, you did it. And that's not quite our ecclesiology. So it requires, again, ecclesiology that understands where your local law bumps up and doesn't feel comfortable. And so you need to be able to say either we clearly fit this or we believe this is not quite right. Yes.
More question about functionality, perhaps, and it's off from the local church. It's in Southern Baptist Life.
Mm-hmm.
You spoke about the strong CEO and then the trustees that rubber stamp. What type of responsibility do you see the trustees have toward the functioning of a board on the SBC level?
You know, I gave a very careful answer to that question to somebody not long ago online, and so I will not do better than I had given to him. But again, my understanding of the law, again, says the trustees are ultimately legally responsible for the organization. And so I think we did go through a time in history when we thought, well, what really makes a good organization is an amazing sole leader. You want a Lee Iacocca or a Steve Jobs. And and it's a little frightening to think anyone would think a good pastor or even a good Baptist CEO would be like Steve Jobs, but people think that. Instead, I think the trustees as a group have the authority and responsibility to make sure that the organization meets its both legal obligations and its obligations back to the group that's put it there. In Baptist Convention life, that means the messengers and the churches of the convention. So, no, it's not my belief that Baptist organizations should operate like that. The trustees are there and have the ultimate responsibility, and to the extent they abdicate that responsibility to even a wonderful leader, they're not allowing that process to work like it should.